right. It is Thursday, December 26th, the day after Christmas. Welcome back to another episode of Hawk Droppings. I'm Hawk. I'm your host. I hope everybody had a wonderful Christmas Eve and Christmas Day, and that, if you did have to spend time with family, I hope it was tolerable, if not outright enjoyable. So, today we're going to talk about the trial court's decision on presidential immunity, written by Judge Juan Merchan, New York Superior Court, and this is related to the criminal convictions on 34 felony counts for falsification of business records that Donald Trump received from a jury earlier this year in a Manhattan courtroom. The Supreme Court issued its decision on presidential immunity on July 1st of this year. That was after Donald Trump's conviction in this case. He thereafter filed a motion to dismiss the indictment and to vacate the jury's verdict based on some components of that Supreme Court decision. So there's an off-brand conditioner here at the cabin, so my hair is herring today, I guess, because I took a shower yesterday, but it's just went, so it is what it is. So let's dive in. In these types of decisions, whether it's written by a judge or it's a proposed order that is written by an attorney in a case that he or she wants the judge to sign, these things will start out with a section it's either an introduction or here's the background of the case and a procedural history. The procedural history, and Judge Merchan does that with this decision. He starts out with procedurally, here are all of the things that have occurred in this case. It's a timeline of the case that have gotten us to this point where I'm issuing this decision and order relative to Donald Trump's immunity claims within this criminal case based on the Supreme Court's July 1st decision on presidential immunity. So, some of this stuff I'm going to read. Some of this stuff I'm just going to kind of summarize. The decision itself is about 40 pages long, and it's very readable. It's very well written. And that, I will email a link to this document to my brother, Falcon, so that he can put it in the show notes. So if you guys want to bring up that document and read along with it as I'm going, that would probably be helpful and enjoyable. And, if you're like me, for information to stick, if it comes from a visual and hearing portal as well as being able to read it as well, that's beneficial for me. But one thing that I wanted to comment on in all of these cases, whether it's Judge Tanya Chutkan in Washington, D.C. on Jack Smith's January 6th indictments and Trump's efforts to overturn the 2020 election, whether it's Judge Juan Merchan in the Manhattan criminal case, or whether it's Judge Engeron in the civil case that the New York Attorney General brought against Trump, his two sons, and the Trump Organization for fraud that resulted in Trump owing the state of New York like $500 million or whatever. I don't remember the exact figure. Or of the decisions and orders written by the judge in the two E. Jean Carroll cases. To a person in all of these cases, except for Aileen Cannon, in the Mar-a-Lago classified documents case, every other judge that I've seen in every of these other cases are serious people. They're serious, they're thoughtful, They're very thorough. They're very detailed in their writings, and they're good writers as well. They to a person they have written decisions and orders and rulings that are thorough and detailed, but also readable. Uh, and in the case of Judge Engeron, in that New York civil case from the Attorney General, that trial was a bench trial. It was not a jury trial. And so he was the one who rendered the verdict in the case after hearing the evidence. And his final decision and order in that case, it's something like 98 pages long. And it is a thorough and exhaustive recounting of the trial and of the evidence at trial, including a section for almost every single witness, where he details their testimony, and then he details his analysis of those witnesses and their testimony as far as how much weight and credibility he is assigning to each one of those witnesses and their testimony. And some of them he assigned no weight and no credibility at all. it's a that it's 98 pages long. It's single spaced. It's a hard read, but it's well written, and very detailed and well reasoned. So, getting back to this one, this decision was issued about a week and a half ago, December 16th, 2024, after much delay. Because remember, it's like the trial. So trial commenced in this case on April 15th and continued through May 29th, 2024, when the jury received the case to begin deliberations. The following day, on May 30th, the jury returned a verdict of guilty on 34 counts of falsifying business records in the first degree. That same day, the court set a deadline of June 13th for the filing of post-trial motions, and adjourned until July 11th, 2024, which was the original sentencing date. In between, so it was in, the last couple days of May or the first couple days of June when the court set that sentencing date of July 11th. Well, a month later, on July 1st, is when the United States Supreme Court issued its decision on Donald Trump's immunity claims. Also within that window of time, I don't remember the exact date, but also within that window of time was when Donald Trump actually secured the Republican nomination for president of the United States. And so those two things obviously had an impact on the court, because on May 30th, when Trump was convicted by a jury and found guilty on 34 felony counts, the Supreme Court had not issued their immunity decision yet. And so nobody knew what that was going to be. Nobody knew what it was going to look like. I don't think anybody expected it to look like what it actually did end up being, in many respects. In some respects, it wasn't surprising, but we'll talk about that in a minute. And so on July 1st, 2024, the Supreme Court of the United States rendered a landmark decision in Trump v. United States. Defendant filed a pretrial motion in the criminal case in Manhattan that same day, seeking leave of court to file this motion, a motion to dismiss the indictment and vacate the jury's guilty verdict. He filed that letter on the same day, on July 1st. And so within this procedural history, the judge is laying out, here are all of the things that have happened. But he also discusses at great length, here are the times within the context of this specific criminal case that Donald Trump discussed or raised the topic of presidential immunity. And the first time that he did that was on December 22nd, 2022, in a motion for summary judgment he filed in an unrelated case that was brought against him for defamation. That was one of the E. Jean Carroll cases. In that motion, and it's been his overall argument in all of these immunity motions and immunity cases and immunity arguments is that presidents have to be absolutely immune from criminal prosecution for absolutely everything, regardless of what it is. Absolute immunity from criminal prosecution forever, period. And, not even the Supreme Court bought that argument. I mean, the famous argument that were made during a couple of the oral arguments on these motions at the state and federal level was like, could the president order SEAL Team 6 to assassinate his political rivals and be immune from that? And his attorney's responses were, yes, he would be immune from criminal prosecution for that unless he were first impeached by the House and removed from office by the Senate after having been convicted at trial on impeachment. Only then could a president be criminally prosecuted in the criminal courts. It's a stupid argument, and all courts rejected that pretty much. Supreme Court a little bit less so, but I'll preface all of this by saying that this is the worst, most corrupt Supreme Court of the United States that's ever existed at any point in time in my life. So, Trump was arraigned on these 34 felony counts in April 4th, 2023. On June 13th of 2023, defendant was indicted in United States District Court for the Southern District of Florida for the classified documents case. On August 3rd, 2023, the defendant was indicted in Washington, D.C. For interfering with the 2020 presidential election and the results. So again, we're going through the timeline here, all right? And in going through the timeline, that's an opportunity for the court to say, yeah, there are a lot of things here, but I'm gonna highlight the important events that I think either relate to this decision I'm about to make or provide context. And in this document with this judge, he lays all of this stuff out in great detail, I think, in order to provide the context for this decision that he's actually making. So, relative to this criminal case, there were a bunch of pretrial motions filed that were filed around September 29th of 2023. Defendant filed motions in limine. So that term motion in limine, that just means a motion beforehand. And we refer to motions in limine as pretrial motions. And Tanner, all right, he's shoving his food around again. And it's all over the floor. And of course, he can't hear me and he can't see me because there's a trash can in the way. So I'll give you an example. Frequently in the kinds of cases that I do, personal injury, motor vehicle collisions, things like that. A lot of times both sides will retain expert witnesses to offer their expert opinions on things. And there are rules about what expert witnesses are allowed to testify to and what the basis for their testimony can be. And if before a trial happens, if I'm taking the deposition of an expert witness and I make a determination that they have based some of their conclusions upon evidence which they're not supposed to, then I will file a motion in limine, a pretrial motion, to exclude that portion of that expert witness's testimony. Motions in limine are frequently used in that manner to preclude the other side from using certain pieces of evidence or certain testimony. And in making those motions, you have to provide the basis for why you're making that request. And in Trump's pretrial motions in this case, he made motions to preclude from arguing that Trump sought to improperly influence the 2020 election. He sought to preclude the testimony of several witnesses, including Karen McDougal, Stephanie Clifford, aka Stormy Daniels, and to preclude Michael Cohen from testifying, and to preclude the people just means the state, the prosecutor, preclude the people from introducing nearly 100 statements they seek to attribute to President Trump based on witness testimony or tweets or things like that. Notably, the defendant did not raise the defense of presidential immunity, even though he had already done so in a notice to remove this case from state court to federal court. He didn't raise presidential immunity, that issue or that basis for his motions, his pretrial motions. He didn't raise presidential immunity in any of his pretrial motions. And so when he filed a notice to remove the case from state court to federal court because defendants have a shot at getting a better, larger jury pool in federal courts than they do in state courts, the judge in that case was like, no, all of these, every allegation, every factual allegation against Donald Trump in this case is of a personal nature, not of the official capacity of a president in the United States, because he wasn't president yet when almost all of this stuff occurred. So on March 7th, 2024, a couple of weeks before the scheduled trial date in this case, that was the first time that he moved to preclude various pieces of evidence on the grounds of presidential immunity. The court denied those motions as being untimely. He waited too long, didn't include them in his original ones, holding that defendant had multiple opportunities to raise claims of presidential immunity well before March 7th, but failed to do so. Yeah. As noted above, defendant filed this motion after the Supreme Court rendered its decision on July 1st, but after this court's June 13th decision or deadline for the filing of post-trial motions. So the Supreme Court decision came out 2 weeks after the cutoff deadline for both sides to file their post-trial motions in this criminal case. Nevertheless, Judge Merchan, who I think was overwhelmingly, backbreakingly fair to Donald Trump and his defense in this case, said, yes, I will let you file this motion to dismiss the indictment and vacate the jury verdict, even though it's 2 weeks past the deadline that I had set previously. So he lets him file that motion. So then we get to section 2 on page 3 of this decision. Man, I'm talking a lot today. Which is Judge Merchan's analysis of the Supreme Court's immunity decision in Trump v. United States, which stemmed from the January 6th DC case that had been in front of Judge Tanya Chutkan. And she wrote, so Trump filed a motion to dismiss that case based on presidential immunity. I believe that was the first time that that had actually been litigated. And that was somewhere about a year ago, I think. It was November, December, October, somewhere in 2023. And Judge Tanya Chutkan wrote a really excellent decision in that case, very well researched, saying, no, you don't have immunity from any of these things that are alleged in the January 6th indictment. And that was fast-tracked to the D.C. Court of Appeals, and they heard argument and issued a decision in less than a month, affirming Judge Tanya Chutkan's decision that Donald Trump didn't have immunity for anything that he had been indicted for in the January 6th case. And Jack Smith filed a motion for expedited review with the Supreme Court. The Supreme Court sat on that for a little bit and then said, yeah, this issue, it needs our imprimatur, a stamp on this issue, and it needs our, our egos and our importance and our elevated sense of self-importance, to decide this issue. And rather than do it on an expedited basis, the Supreme Court did exactly what Donald Trump wanted them to do. They took it and they set it for oral argument on the last possible day for oral argument in the last term of the Supreme Court, which I think was sometime in April. And then once they heard oral argument in the case, and now you can listen to the audio for that oral argument. Justices Roberts, Thomas, Alito, Kavanaugh, and Gorsuch, the 5 conservative male justices, were incredibly offended during those oral arguments that Donald Trump was even being prosecuted in the first place. I don't know if that overlapped when Sam Alito had, a J6 flag hanging from his flagpole at his house, allegedly. They were extremely hostile to the government in that case, and they were very open to the arguments of Donald Trump's attorney. I think his name is John Sauro, Sauro, who is going to be our incoming Solicitor General in Trump's second term. He will be arguing cases on behalf of the government in front of the United States Supreme Court. Yeah. So that's his reward. But within the context of the United States Supreme Court's immunity decision, they basically broke conduct into 3 areas. If a specific act that a president has been indicted for is an official act of the office of the President of the United States within the bounds of a president's constitutional duties, then he has absolute immunity, he or she. If it is an act of purely personal benefit, then there's no immunity and no presumption of immunity. If an act is within the outer limits or the outer boundaries of a president's official acts or official duties, if it's a little bit of a gray area, then there's a rebuttable presumption of immunity. What does that mean? Anytime you hear the word presumption coming from a court, it's a burden shifting exercise, meaning it shifts the burden of proof from the party who would normally have the burden of proof to the party who normally does not have the burden of proof. And like the example that I give for that, it's like I did family law in California for a decade. And in divorce dissolution cases, if parties have been married for less than 10 years, the rule generally, apart from any extenuating circumstances, is that if one spouse is going to be paying spousal support to the other, you get 1 year of spousal support for every 2 years of marriage. So if you're married for 9 years, you get spousal support for 4.5 years. If you're married for 10 years or longer, there is a presumption for lifetime spousal support. And what does that do? It shifts the burden from the spouse who would be receiving support, their burden of proof to demonstrate that they need it. It shifts that burden to the spouse who would be paying spousal support to prove that lifetime support would be a miscarriage of justice for any number of reasons. But it puts the burden of proof, it shifts it to the other party. And so in this context, a rebuttable presumption of immunity for acts within the outer perimeter of his official duties, it shifts that burden. So it means that Donald Trump doesn't have to prove that it's an official act. It shifts that burden of proof to the government to prove that it was not an official act and it was in actuality an act for his own personal benefit. So that's what that means. So we got these three buckets. And the Supreme Court invented all of that. They invented every bit of that. There's none of that in the Constitution. And they're using terms like, the president sometimes acts in a zone of twilight, and the reasons that justify absolute immunity do not apply to those acts before deciding which acts fall within this zone of twilight. The Supreme Court recognized that only a limited number of our prior decisions guide determination of the president's immunity in this context, which is to say none. Notably, this is notably absent, of course, was any precedent where a president was criminally charged for actions taken while in office, the specific issue the Supreme Court was tasked with determining. There was zero precedent for this. None. Everything in that Supreme Court decision is made up, fabricated, and invented. It's not in the Constitution anywhere. And they did it anyway. And one of the other things that they did, they tried to extrapolate, like, Bill Clinton's civil cases and Nixon v. Fitzgerald and stuff like that. And in writing this the way that he did, Judge Merchan is basically giving an FU to the Supreme Court. He's saying they had no precedent whatsoever upon which to base this decision. And he says that in a very professional, articulate manner without insulting anyone personally. They cite the Fitzgerald case, which held that a president must be absolutely immune from damages liability, like money, for acts within the outer perimeter of his official duties. And, so the whole point of analyzing, the one other thing, and this is the meat of it, one other thing that the Supreme Court invented in their Trump immunity decision, and they just flat out invented it. The decision itself was 6-3 conservatives with the 3 liberal justices, except for one section of the decision. I think it's section 3, that it was a 5-4 decision because Amy Coney Barrett was like, not even I am signing on for this bullshit from this one section. And this one section, section 3, they just invented. They were like, if a president does something that is clearly criminal while in office for which he has no immunity, you cannot use any evidence of official acts which would support that finding of criminality. You can't question a president's motives in committing a criminal act. And one example that they carved out was Donald Trump in the final days of his administration leading up to January 6th and beyond until January 20th. Trump tried to take over the Department of Justice. And he tried to do that with DOJ environmental lawyer Jeffrey Clark, who was totally on board with using the DOJ to send out letters from the DOJ to swing states saying, we believe there was fraud committed in your specific state elections. And we're investigating that now, so don't certify your election results. And we may need an alternate slate of electors from you, just in case. Which was bullshit. It was an absolute abuse of power. It was a misuse of executive authority. He was intending to use the Department of Justice to commit fraud in his efforts to stay in office. And the Supreme Court was like, yeah, he gets absolute immunity for all of that because it is part of a president's executive function and the core constitutional duties for him to communicate with the Department of Justice. So you can't look at his motives for the things that you are accusing him of doing, and you can't prosecute him for any of those things because you're not allowed to look at his motive or his intent. Yeah, they just made that up. And that's the part of that decision that applies to this case, because Donald Trump picked a few categories of evidence and he was arguing to the court that these fall into that category of Section 3 from the Supreme Court's immunity decision. They're evidence of official acts that the prosecutor is using to either get at motive or intent or support the indictments and accusations for these 34 felony counts. And the Supreme Court says you're not allowed to do that. You can't use this evidence in that way. And that's the meat of his argument in this motion. So, part 3, page 7. Arguments of the parties. Defendant moves to dismiss the indictment and vacate the jury verdict on grounds that the people introduced evidence in the grand jury phase and at trial relating to defendant's official acts as president, in violation of the presidential immunity doctrine as pronounced by the Supreme Court in its immunity decision on July 1st. Defendant further argues that the alleged violation is not subject to harmless error, and even if it were, the harm caused is irreparable. So, harmless error is a standard of review on appeal, basically. It's like, even if one side does something that's improper, if it would not have impacted the outcome of the case, a jury's verdict or a judge's decision, then it's deemed to be harmless error. It's like, yeah, a mistake was made, but it was harmless, so you don't get to overturn the case. Because the people in this case argue a few things. First of all, when all of this evidence was coming in at trial, Trump and his attorneys didn't object to it, except for two instances. And if you don't object to something at trial, you don't get to appeal it after trial, okay? If a witness is on the stand just spouting off all kinds of hearsay evidence, and the attorney who is adverse to that witness doesn't say objection, hearsay, then when the trial is done, you don't get to make an argument on appeal that the judge mistakenly let that evidence in at trial because you didn't object to it when it was happening. If you don't object at the moment that it's happening in trial, and if you don't object in a way that covers all of your bases for objections, you don't get to object, or you don't get to appeal that stuff later on. So it's like, not only do you have to object, you have to have your bases covered and make sure that you're objecting on all of the relevant grounds that you think you might need on appeal after the trial is over. And so there were a bunch of instances with this evidence where Trump's attorneys did not object at all, and or did not object on the basis of presidential immunity. They did object on the basis of presidential immunity to the trial of, the testimony of Hope Hicks, who had been his personal assistant in the White House. And then there was some government financial disclosure form. They objected to that on the basis of presidential immunity as well. However, and the court is like, if you didn't object on this basis at trial, you don't get to raise that objection now. And again, the judge was like, however, we now have this Supreme Court case, so I'm going to go through the analysis on all of these pieces of evidence anyway. And he does. We get to part 4, where it states the law about the law that supports these types of motions. And then part 5, we get to the discussion. And the discussion section, where it's like the judge is applying the law to the facts and doing his analysis, he starts off with objections, preservation, and basically saying, if you don't object at trial, you don't get to bring this stuff up later on. Trump makes arguments saying, I don't have to do that. I did it once in a pretrial motion, which he didn't. He's trying to say that, he also tries to argue that, well, I objected to it in the E. Jean Carroll case, so I raised that, and that's a New York court, so that applies in this court as well. The judge is like, nope. The intervening Supreme Court decision in the immunity case does not excuse a failure by defendant to adequately preserve his objections to the evidence at trial that he now claims was erroneously admitted. The judge is like, you didn't object, dude, so you don't get to bring it up now. But because you're a former president and you now have the nomination for the Republican Party, and because we have the Supreme Court decision, I will consider these things as though you did object at trial. And then, so he goes through, he inserts on page 12 part of the trial transcript where one of his attorneys, Mr. Bove, did say we want to put on record our objection on presidential immunity grounds regarding the testimony of Hope Hicks, and the prosecutor opposed it, and the court said, I think I've ruled on this previously. He did. So the objection is noted. I don't think you'll need to object to each question. You know, your objection as to Hope Hicks' testimony is preserved. He did the same thing with regard to some financial disclosure form. You know, but then, so then we get to, I'm going to skip some of this stuff. Then there's an analysis of, wait a minute. So, okay, so some of the specific evidences, the testimony of Hope Hicks, the testimony of a woman named Rebecca Westerhout. There were a bunch of tweets that they wanted to keep out. The testimony of Michael Cohen, this official government financial form. And so the judge goes through an exhaustive analysis of what is this evidence? What is its relevance? Did defense object and preserve their objection for appeal? And then even if this evidence were excluded, would that have any impact on the jury's verdict to determine whether or not it's harmless error? And so he goes through all of the Cohen testimony. And the interesting thing is, it's like, it just gives the judge an opportunity to just recount all of the negative evidence again and just lay out all of the negative evidence again. And the judge notes a few times in this decision, even if you take all of these discrete pieces of evidence out, there is an overwhelming amount of evidence of guilt for defendant in this case, which supports the eventual finding that even if it was let in, that's harmless error, even if it was supposed to be excluded, because it would not have affected the jury's verdict, because there is an overwhelming amount of additional evidence of defendant's guilt in this case. And so much of it was documentary. I mean, they had all the canceled checks, they had all these agreements, they had all these memos, you know, they had the testimony of David Pecker, the guy who was running the National Enquirer. And, you know, so, I mean, for this, I'm almost 40 minutes in, so I'm not going to go through all of the evidence itself. Just suffice it to say that the judge goes through that analysis, which with each piece of evidence that's contested in this motion. And so then the next section within that section is, well, so the conclusion there is, despite defendant's failure to preserve the objections he raises in this current motion, other than those pertaining to Ms. Hicks and a couple of other exhibits, this court will nonetheless consider his motion on the merits in its entirety. It's like, you didn't do the shit you were supposed to do at trial, which normally would preclude you from bringing this all up now, but because this case is this case and you are you, I'm going to act like that didn't happen. So then there's a lengthy discussion in this order about official versus unofficial acts. And the judge starts out by saying, unlike in the Supreme Court's immunity decision, this court need not decide whether the crimes of which defendant was convicted constitute official acts, because the defendant concedes that they were decidedly unofficial. They were for his personal benefit. The much narrower issue presented here is whether a discrete subset of evidence admitted at trial constituted official acts deserving of some level of immunity, whether it be absolute or presumptive. To evaluate each of those claims, it is important to understand the context of unofficial acts for which the defendant stands convicted. right there, the middle of page 16. The trial court judge says that Donald Trump stands convicted of 34 felony counts. So now when you get those Gomer MAGA chuds saying he was never convicted because he wasn't sentenced, just say, well, just look at page 16 of the judge's order dated December 16th. Let me read that again. It is important to understand the context of the official acts for which defendant stands convicted. I would wager that someone who has been a New York criminal court trial judge for over 20 years has a better understanding of the definitions of these terms than some yokel Gomer with 7 teeth who watches Tucker Carlson. But that's just me. What do I know? I'm just a dumb country lawyer. All right. So there's that discussion. And the judge narrows it down even further. He's like, it's like, yeah, in the oral arguments for the Supreme Court immunity decision, they were talking about a lot of hypotheticals, and there was hypothetically this and hypothetically that. And he's like, but, hypotheticals are great. But one would be hard-pressed to devise a hypothetical more on point to guide the analysis here between official and unofficial conduct than the case at bar. And he poses the following question. Is a president's in-office conduct to conceal payments to an adult film actress to keep information from the public eye relating to an encounter that occurred prior to his presidency official or unofficial? There's only one answer to that question. This is all unofficial. And then he goes through the testimony of Hope Hicks. And he closes out each of these sections with a very similar paragraph. The people argue that the communications that Trump had with Hope Hicks, which are the subject of this motion, constitute unofficial acts not entitled to any level of immunity, and submit that even if the court were to find that the communications fall within the outer perimeter of defendant's authority, subject to presumptive immunity, that the presumption has been rebutted by ample evidence unrelated to motive as required under the Supreme Court's decision. And the judge agrees with that. Let me find it. And then he does the same analysis of the testimony of Madeleine Westerholt, which was like a schedule coordinator for him. Makes the same conclusion there. And then he goes through this Office of Government Ethics Forum financial disclosure. He makes the same conclusion there. Then he goes through the testimony of Michael Cohen. And that analysis is a little more detailed. I mean, because Michael Cohen was on the stand, I think, for 3 full days. Most of that under cross-examination. And he goes through in detail, a couple of instances where defense had filed pretrial motions to preclude the testimony of Michael Cohen on specific areas. But then when defense got up to do redirect, they're like, hey, they opened the door. They violated their own pretrial order. So now we do get to question him on this stuff. And the judge is like, yeah, you're right. You open the door. Proceed, counsel. And then, we get to tweets. There's a whole lot more on Michael Cohen's testimony, Trump's Twitter posts, and the court determines that every single piece of evidence that Donald Trump has contested as being official acts, this court finds all of these are unofficial acts and they do not qualify for immunity, which brings up the next point, harmless error. And so the people argue that if this court concludes that any evidence of official presidential acts were improperly admitted at trial, defendant's request to set aside the verdict should be rejected on harmless error grounds. In response, defendant argues that harmless error does not apply here because federal constitutional reasoning forecloses harmless error analysis under New York law. He's basically saying that the court can't even consider whether it's harmless error because we're dealing with the United States Constitution and issues of incredible importance under the United States Constitution, and that precludes New York state law. And the judge is like, nah, you're wrong. So he goes through an analysis on that. So I'll read the conclusion from that section. In addition to presiding over every stage of these proceedings, and this trial lasted for 5 or 6 weeks, this court has carefully scrutinized the trial record, including all evidence, such as invoices. This is where he lists all the other evidence. Invoices, general ledger entries, recorded phone conversations, text messages, emails, Alan Weisselberg's handwritten notes, and video footage. This also includes testimony from Michael Cohen, Stormy Daniels, Mr. McConney, Keith Davidson, Mr. Pecker, and Gary Farrow, to name but a fraction of the evidence the jury heard and considered separate and apart from that evidence and select testimony which defendant now challenges on presidential immunity grounds. So, this court, here's the money sentence. This court concludes that if error occurred regarding the introduction of the challenged evidence, which this court does not conclude that, and such error were excised, such error was harmless in light of the overwhelming evidence of guilt. So, that brings us to the overall conclusion. This court finds that defendant properly objected, preserved his claims at trial only as to the testimony of Hope Hicks, that government financial disclosure, and a couple of Twitter posts. All other claims are denied as unpreserved, meaning you didn't object to them at trial. The judge said, I would consider your arguments even though you didn't object at trial. But in the final conclusion, the order, he's like, you didn't object to any of this other stuff, so denied. The court further finds that the evidence related to the preserved claims relate entirely to unofficial conduct and thus receive no immunity protections, be it absolute or presumed. Zero immunity. As to the claims that were unpreserved, no objections made at trial, this court finds in the alternative that when considered on the merits, they too are denied because they relate to entirely unofficial conduct entitled to no immunity protections. Further, even if this court were to deem that all of the contested evidence, both preserved and unpreserved, as official conduct, falling within the outer perimeter of defendant's presidential authority, it would still find that the prosecutor's use of these acts as evidence of the decidedly personal acts of falsifying business records poses no danger of intrusion on the authority and function of the executive branch, a conclusion amply supported by non-motive related evidence. Lastly, this court concludes that if error occurred regarding the introduction of the challenged evidence, such error was harmless in light of the overwhelming evidence of guilt. Defendant's motion is denied. It's a great read. I mean, you know, if you're into that kind of thing. I enjoyed it immensely. It's well written. The reasoning is easy to follow. It's properly decided, I think. He clowns on the Supreme Court a bunch in very subtle but very clear ways, which I appreciate immensely. All right, so that concludes today's dramatic reading of court documents. Yeah, because that's what you want to do on Christmas vacation. All right, everybody, thank you for subscribing. If you enjoy this, please go to our YouTube page. We're trying to build up those numbers just in case TikTok goes away. And you can just go to YouTube, go into the search bar and type in Hawk Podcasts, and our page will pop right up. The audio for this podcast will appear for free on that page as well. Okay, I'm going to go for a walk. Thanks everybody for listening. Thank you for subscribing. Please go check out our YouTube page. I hope everybody had a great Christmas. And New Year's is right around the corner. So for the next week or 10 days until we get over that hump, please be safe and, don't do anything stupid. Which, it's advice I could have used a few days ago, but whatever. Merry Christmas, everybody. Thank you for listening, and I will talk to you soon. See you guys.